last week on Thursday, 12th March 2026, the House stood over the debate on the motion for the second reading of the bill, pending clarifications of the contentious issues arising out of Clause 9 of the bill, which is a gist of this bill. We, as I said before, we had a clarification on that clause. However, I will allow the debate to continue. Then that clarification will be made when we reach committee stage. But I want to reiterate this. Nobody should imagine that we didn't want to make the bill. And it is also not prudent for people to sit wherever they sit and start saying we members of parliament are ignorant. We are not ignorant. We are here to work for the public. The debate is open.
Right, Honorable Speaker, thank you so much. You just mentioned in your communication that yes, indeed the House debated that report and was supposed to proceed on the committee stage. Are we therefore proceeding well when we say that we go back to the debate instead of going straight to the committee stage?
I said we are continuing with the debate.
Right, Honorable Speaker, thank you so much. Actually, it is very important that we continue with the debate for people out there in the public to see and listen to what different thoughts are. Because,
Christine, is that in the report?
Right, Honorable Speaker, I'm discussing Article 9 of the report, of the committee
I have
report.
said Article Clause 9 will be discussed when we are at committee stage.
I am saying that based on the report, we file the different stakeholders. For example, when you look at the upcoming and the already established, the report is not bringing out the difference of the interests of these two groups and the expiry of the consideration of the different interests. Because this did not come out, Right Honorable Speaker, in the report, when the interests have an expiry date, that is a consideration for you for this period of time. Right Honorable Speaker, the freedom, I still emphasize that the freedom of when something is exposed to the public, the freedom of the public to enjoy something produced for the public is also missing. To what extent should the public enjoy what you have put forward, especially when you have put it forward? If, as a right, if you didn't want the public to enjoy at all, then to what extent should the public be given that freedom to enjoy what you have put on table? That is still a question from the report, Right Honorable Speaker. Thank you.
Thank you.
Thank you, Right Honorable Speaker. And I thank the Honorable Member for the question. I'll just make this analogy. I manufacture a car for purposes of selling it. But because I manufactured it for purposes of selling it for the public to use, we cannot argue that I should be able to access that car without paying for it. Now, this copyright is that property. It is what the artist has made. And he has made it for the purpose of the public using it, but he has made it for the purpose of gaining from it. So this law has provided the instances how you could use it. If you want to enter into an agreement with the artist, you could enter the agreement, and the artist could give you time. And there are limits. 20 years, 15 years, all those are provided for in the Act. So the right of the public to use the works of the artist are regulated by the law. It is not that when they produce the music, you are at liberty to use it for your benefit, for your commercial benefit, without them benefiting from it. So, yes, it's provided for. If you want to use it, you can agree with them. If you want to sell it, you can also agree with them on how you can sell it. So we need to look at it as the property, that this copyright is the property of the artist, and you would like to use that property. How do you want to use the property?
This is a house, they don't clap. Place.
So yes, the way the law is structured, the way the copyright law is structured, it is alive to the fact that the artist would like to sell that product. But how do they sell that product to the public? That's what the law is trying to regulate.
And Christine, you also have an option, the product. Then you decide not to. But if you want to enjoy, you must be able to pay the owner of the product. You get it, eh? Zach,
And I've interacted severely with very many upcoming gospel artists, including the pastors that are ministers over the same. Right, Honorable Speaker, I'm not so certain whether all stakeholders were consulted enough to accommodate their input into this bill, and yet it is for public consumption. Right, Honorable Speaker, in accordance to Luke chapter 6, verse 38, if permission granted to read it verbally.
Honorable Tebandeke, you're only speculating. There was an advert, which was even paid by Parliament of Uganda, inviting everybody to come and bring their views. And when you look at the report, it's unfortunate that when they read the report, you're not here. It gave all the people who came here. So if somebody missed out, we cannot go and pick somebody from their homes to come and give their views. So we will take the views that were given and consider the bill. We are not going to keep this bill forever. Okay? Honorable members, I put a question that the Copyright and Neighboring Rights Amendment Bill 2025 be read the second time. Those in favor say the contrary nay. The ayes have it.
The Copyright and Neighboring Rights Amendment Bill to
amendments to Clause 1 in the following terms. Clause 1 is amended in paragraph 1A as follows. In the definition of broadcasting, by inserting immediately before the word wireless, the word wire.
Chair, can we stand over Clause 1 in case we shall get something else to define?
Fine, in the definition. Thank you.
Clause 2.
The new clause immediately after Clause 3 in the following terms. The bill is amended by inserting immediately after Clause 3 the following. The Principal Act is amended by inserting immediately after Clause 4 the following. 4A, artificial intelligence work to be protected. Works generated by an artificial intelligence system.
Immediately after Clause 3.
Yeah. Immediately after Clause 3, which will be 4A. And 4A is, the head note is artificial intelligence work to be protected. Works and 4A1, works to be generated by an artificial intelligence system shall be eligible for copyright protection if the works, A, has been supervised, directed, or substantially modified by a natural person, and B is original. 4A2, a developer or user who intends to develop any work using an artificial intelligence system shall, 2A, obtain the consent of the author of the work to be used in a training data set, and B, maintain publicly accessible records of the general categories and sources of content used in training data set. 4A3, a developer shall implement technical safeguards to prevent the reproduction of training data and shall provide clear usage guidelines to users to the use of artificial intelligence tools. 4A4, the minister may, by statutory instrument, A, regulate the use of corporate works in artificial intelligence systems, and B, prescribe the criteria to be applied to works generated using artificial intelligence systems to determine whether the work is original. Justification, Madam Chair, to provide for works which are eligible for corporate protection and the use of corporate material in artificial intelligence systems. 2, to empower the minister to prescribe the criteria to be applied to works generated using artificial intelligence systems to determine whether the work is original. I beg to move, Madam Chair.
We propose that that provision, that insertion be dropped by the House. Right Honorable Speaker, AI is a tool. It's a tool used to generate protected work. AI is not this act is not intended to regulate tools. For example, a musician uses an organ, a drum, a long drum. This act is not about the tools that you use to generate the works. This act is about the works themselves. So the AI policy is much wider, and government is currently working on AI policy on how to regulate and guide people on its use. But to say that we should attach certain value to how the copyright was made would not be appropriate. We propose that that proposed amendment be dropped.
Madam Chair, considering that you want to allow debate on this, Madam? Considering that, Madam Chair, we have made a recommendation.
Do you have any law on AI?
We have made a recommendation in our report that
No, I'm
government
saying, do you
picks-
have a law that you're referring on AI for
No,
you to borrow?
we received the
And in the
permission.
circumstance that you don't have, then just concede.
Yeah, can I just make a statement and conclude, Madam Chair, and then you rule? Madam Chair, first of all, I concur with the Attorney General for now that provisions relating to AI need to be looked into further. And we made a recommendation to that effect, that government should pick interest in AI matters and amend the Corporate Act further. But for now, I concede.
Clause 4.
5 is amended in the paragraph B by substituting for subsection 4 the following. A contract of assignment, license, or transfer to do an act falling within a corporate shall be in writing. Justification for completeness to harmonize the provision with the head note by including the assignment and transfer of a contract in the proposed subsection 4. I beg to move.
Thank you.
We have no objection to that proposed amendment. The import of it is that if you want to deal with an assignment or a license of the use of any person's copyright, you can only do so by showing that you have a contract in writing. We do concede.
Thank you. I put a question that clause 5 be amended as proposed. Those in favor say on the contrary, nay.
The committee proposes to insert Section 13A and 13B in the Principal Act, and therefore Clause 6 will be amended as follows. By substituting the proposed Section 13A, the following. 13A, reversion of economic rights in copyright to author. 13A1, in a contract of assignment, license, or transfer, there is an implied term that the economic rights in a copyright shall revert to the author. A, upon termination of the contract of assignment or license or transfer. B, upon expiry of the term of the contract of assignment, license, or transfer. C, if the hold of the economic rights in the contract of assignment, license, or transfer becomes insolvent or bankrupt and can no longer meet the contractual obligations to the author. D, where the contract of assignment, license, or transfer covers the right of publication, the work goes out of print or becomes unavailable or for a reasonable time. E, 5 years before the expiry of the duration of the protection of the copyright works under this act. Or F, for any other reason as may be prescribed by the minister by statutory instrument. 13A2, the minister may by statutory instrument prescribe the procedure of reverting the assignment, license, or transfer of copyright to the author. 13AB, in section 13B1, the proposed paragraphs A and B by deleting the word effective wherever the word appears in the provision. And in the proposed paragraph B, by inserting immediately after the word technological, wherever the word appears, the word protection. Justification, Madam Chair. The proposed 13A is replaced since the provision as proposed in the bill will frustrate freedom of contract and unlawfully deprives copyright owners the full utilization of their rights. The second justification, to adopt international best practices that allow the reversion of the rights of an author under specific circumstances. The other justification, to empower authors who have assigned their rights in a copyright works for the life of the copyright prior to the commencement of the Copyright and Neighboring Rights Act to claim back their rights 5 years before the statutory protection of the rights, and the amendment proposed in 13B are intended to delete the word effective since the word is redundant and subjective, and to insert the word protection in order to harmonize the provision with the usage of the word under the World Intellectual Property Framework. I beg to move, Madam Chair.
Honorable Speaker and honorable colleagues, the proposed replacement of clause 13A by the committee will not work in the best interest of the author. The purpose of the proposal that has been made by government is that you cannot have a copyright on any person's works for a period longer than 20 years. And that and 5 years before that, the owner of the copyright is at liberty to come and take this property back. What this clause is doing, it is mixing up the consequence of termination with the right for reversion. So what we are discussing here is the right of the author to get their works back after the 20 years, and you cannot have a copyright for, say, 40 years. It can only be a maximum of 20 years. You can write another contract. But the purpose of this was to ensure that if an author, for example, in year 1, entered into a contract for a long period, which was, say, unfair because of the bargaining power, after some time they can get benefit back of their product. We propose, Right Honourable Speaker and honourable colleagues, that this proposal be dropped and clause 6 stands as part of the bill as proposed by government. We so submit.
And the chair of the committee. Madam Chair, you see, in the copyright law, I composed my song. And after composing my song, a certain man wants to buy my album. Remember, some time back, there was no TikTok, there was no whatever they use on social media. And this man, Kasiwukira, may he so rest in peace, bought my music. But by that time, I never had the capacity to record a video out of my music. But has the right over the song. I don't know whether Attorney General, you are following what I'm saying. Now, because it is my song, I composed it. Now, he paid me, he has been selling my music, I got my money. But now I'm composing, I'm putting in a video. I'm recording a video which I'm also going to sell. I want to say how this musician is protected under that direction. Because he's putting his music on TikTok, he's putting it on YouTube, which were not present at that particular time. But now the advantages he's using to sell and get money, which were not available by the other person who had bought the copyright by that time. Can you help me get that one, that particular clause?
The heading of the clause, reversal of copyright to an author. So let's discuss according to that. You get it? Eh? We are looking at when do you reverse, how do you reverse. Let's be systematic. move as per the clause. Okay?
Members, I beg to move that the report from the Committee of the Whole House be adopted.
I put a question that the report of the Committee of the Whole House be adopted by this House. Those in favor say on the contrary, nay. The ayes have it.
Bills, third reading, the Copyright Rights Amendment Bill 2025.
Honorable Minister.
Right, Honorable Speaker and Honorable Members, I beg to move Copyright and Neighboring Rights Amendment Bill 2025 be read for the third time and do pass.
I put a question that the Copyright and Neighboring Rights Amendment Bill 2025 be read the third time and do pass. Those in favor say the contrary, nay. The ayes have it.
A bill for an act titled the Copyright and Neighboring Rights Amendment Act 20.
Settled, and the bill passed. You can now say what you want to say.
Community, government did take over the bill, and the law does allow, and here we are. Let me say, you know, we pass many bills here, and normally the problem is implementation. So I have seen, and the artists are very excited that the bill has been passed. We are all excited that the bill has been passed. But I hope we are not going to have run-ins when it comes to implementation. That's normally the problem. So the bills gather dust and they're not acted upon. And then the excitement ends up fading. I hope we don't get to that point. That said, Honorable Speaker, the old law of 2006 had regulations of 2010 that came through in 2010. We hope that there will be new regulations to actualize, because now this is an amended bill, so we cannot rely on the 2010 regulations. We hope that there will be regulations that will come through to harmonize and actualize some of the things, because there was still some pettifogging over some clauses and so on, but the regulations help to remedy that. I hope that they will come through soon enough so that then actualizing of this new law gets to happen. With your permission, Right Honourable Speaker, kindly allow a 30-second comment from the Shadow Minister for Arts, who is the initiator of this bill.
Honourable.
And he's also part of the community. With your permission, right.